my thought, and I would run it in the way I see fit. And if you don't like it, you can leave.
So Roxy,
Yes.
practicing law from the bench, right?
I think you can't.
Are you practicing law from the bench? If you run
Pretend to be like that, Mr. Timmy.
Right.
I hold you in contempt and have you detained. Stop wasting my time.
Oh no, nothing's worse than Timmy with authority.
Bye-bye now.
Timmy.
The OT Act is not actually based off of the OT Act and the Care of Children Act originally. It is based off of the 1968 Guardianship Act.
Okay.
And so the Care of Children Act that we have now was originally to guard the 1968 Guardianship Act. So when you were dealing with guardianship back in those days, there was no custody.
It was just guardianship, and that meant you got everything, including the custody.
Yes, and then what ended up happening was they changed it around so that it went to custody, right? Because guardianship is defined as detaining an individual, and it's illegal to detain.
Which is a breach of Section 22 of BORA.
Yes, and it actually comes under the Magna Carta in that as well.
Yeah, they don't like it when you bring the Magna Carta in, though. A lot of them will just ignore the Magna Carta being dragged in.
Oh, exactly, yeah, exactly. But when it comes down to it, it was just the interesting phase to go through on the journey to find out, well, hold on a minute, the family court originally started in 1978 as the umbrella of the district court, which surprised me because...
so it's a secondary court to the district court. So surely...
Well, I remember my mum having, well, back as what they termed as custody back in those days, custody in 1975. So to me it was sort of, how'd they get 1978 then?
Must have done it a different way. So what was done pre-78 before the Guardianship Act?
No, everything was done under the Department of Social Welfare back then.
Oh, of course.
Yeah. So the Department of Social Welfare, they were under the Social Security Act, and so all of the stuff that was to do with custody was under the Social Security Act.
Right. That's sort of that's sort of like the primary one for all of them, isn't it?
Yes, but here's the kicker too. Here's a kicker one too. People look at the Care of Children Act and they go along and go, oh yep, we've got all of these different sections under the Care of Children Act. Right? Lo and behold, here you are, you think you've got everything sorted. And then you find out there's not only 165 sections under the Care of Children Act. There is another 300 underneath the Family Court Rules 2002 Part 2 at the bottom of the Family Court Rules.
And of course they always hide it in some other obscure fucking legislation hidden in some back-end schedule. You know?
You know, it actually just says Care of Children Act Part 2 at the bottom of the Family Court Rules 2002.
Wow. And a lot of people won't make it all the way down to notice.
Yeah, I was looking up something in the Care of Children Act and I noticed, hold on, what's this Part 2? So I clicked on Part 2 and it went to the Family Court Rules. I was like, huh? They actually got to do with Family Court Rules. So I thought, scroll down the bottom, Care of Children Act Part 2.
You should be able to separate that and put it out as an individual document.
Well, that's what I was thinking about doing, was joining the two together at some stage, and you know, having a PDF, because I can read the PDF. So I'm thinking about doing that actually, because there's also the other one that people probably are not aware of is the High Court Rules 2016. You've got like all your different rules there.
How many rules are in the High Court Rules? Well, answer it from a registrar's perspective.
From a registrar's point of view, I think in the 2016, I think there's something like 30 or 40 different rules, but with subsections there. But in reality, if you go back to 2009, then the High Court Rules of 2009 has 900 rules.
And that hasn't been repealed, so that's all still active.
That's right, and it's just the same as...
and do the registrars know about that?
Oh, yeah, I raised it with them. I did raise it with them. I said, we're going by the High Court Rules. Yeah, 2009 or 2016? Well, what do you mean 2009? The 900 rule one or the 3540 rule one? Which one remember?
Yeah, they simplified it down, didn't they?
They've simplified it down, but I think it's also because if you read half the things that are in the 2009 one, there's so much more you can do.
Yeah, it's like
I just don't want to. I just don't want to read 900 sections, 900 rules, you know.
Just chisel away at it when you need to.
I just took one look at it. I was like, oh hell, man! I thought 400 pages was bad enough.
Yeah.
But, I look at the Black's Law Dictionary that I downloaded, and I'm like, oh, 4,500 pages, no thanks.
Yeah, there's quite a few, isn't there?
Oh yeah.
Wow.
But I mean, it's just one of those things where.
So Black's gone, and we can all be happy about that. Thank fuck. And a lot of people reckon you can't recuse judges.
Well, here's what I would say to all of those people that say you can't recuse a judge. Don't try. Okay? I made the application for one reason. I had already done so many complaints and was judicial reviewing them. I knew that he would have been given a copy of each complaint, and I was aware that he would have now known I was judicial reviewing the complaint because the Judicial Conduct Commissioner did not uphold it. So that was why I went for recuse them.
Yeah. But it wasn't in an attempt to bully him now, was it?
No, it certainly wasn't. What was,
Can't believe he called you a bully.
To me, it was more an attempt to.
He must have been looking in a mirror. You weren't holding a mirror in front of your head or anything.
Well, put it this way: with having to look forward at him, I wish I was. But the reality of the whole thing really came down to the fact that I think he knew he had to go anyway, because on the 8th of March, he literally got up and left the courtroom.
Yeah.
In the first 10 minutes, he got up and left. Right. And then I got reminded by an old trial group the other night, because the minute they get up and leave, they've lost jurisdiction that day.
Yeah, exactly. He who leaves the courtroom first loses. Simple rule.
It was, but I mean,
or he who leaves the battlefield first loses.
Yeah, I mean, I have been told by other people in the past that he could be a prick and everything like that. I mean, I still remember the day Darren Cassidy told me that watch him because he's one of those ones who will make sure you never see them again. Well, if you're watching Darren, we won.
Yeah, true. And what was that other? I don't know if you can divulge too much into that other story you were telling me about the young fella, the shoplifter.
Yes.
This is another Judge Black, Timmy Black, fucking overreached this one. Disgusting.
Yeah, I mean, I won't say too much in regards to it because I know he's still going through the system.
Sure.
But when a judicial officer breaches their power to the point where they imprison someone for a period of 2 years in maximum security for something like shoplifting, then questions have got to be answered. What the hell is going on in that person's head that's making that decision?
Especially when he's crossing jurisdictions and dealing with the family court matter, and then jumping over to the district court to deal with the shoplifting matter.
And you know what the silly thing is?
That's a conflict of interest right away.
Yep, and here's another one that I forgot. You reminded me of this. Okay, one of the other guys that was in the group. Okay,
yep.
He's going through the same thing as well with Black.
Right.
And this is what he turned around and said. Okay. Now, Black I'd always praised Black. Okay, there was a criminal prosecutions that I started, and that he had dismissed him, and that was. And I told him that day on the recusal, that's a conflict of interest. You shouldn't have even been sitting on.
Exactly.
Right? Now, this is what he turned around and told this other guy. I don't have the ability to sit on your family court proceedings because I'm dealing with your criminal proceedings, and that would be a conflict of interest. Hello, asshole. What took you 3 years to not do that last time with us then?
Exactly.
I think it's more a case of he picks and chooses what he wants to be able to do, but he's got that. I can't understand how someone can be in that position and be so non-impartial and be so biased in regards to that fact, because I even quoted to him a case of Rihi versus Rihi.
Yeah.
Right? And you'll probably remember this happening. It was in the news. The first one where 7AA of the Orangatamari Act was implemented. Yep.
The whole bringing the whānau into it.
That's right. He was the judge on it. He was the one who gave the child back. And I'm trying to figure out, hold on a minute. How is he the judge when he's doing the opposite nowadays?
Yeah, he's looking all fantastic for the media because it's being covered.
That's all it was, because literally it was in 2019, and here's the kicker of it, right? The social worker was our social worker. the lawyer for child was our lawyer for child.
Right. So,
Yeah.
so there's going to be a few more torts of negligence and professional
Well,
negligence
it's
coming out.
what I'm getting at there is...
I think more people need to do that because it's only...
How much
More
much of these three individuals, the judge, the social worker and the lawyer for child, how many families are they doing with them?
Yeah, exactly. I mean, how many years and how many families have they destroyed just to feed their own ego? I mean, Timmy, you know, he was the mayor of Dunedin, and then he moves up to Palmerston North, gets his warrant of appointment, and then he comes up to Auckland, fucks with me in 2017. He's still fucking with people down in Invercargill because he, you know, being the ex-mayor, he's like I said to you before, he's probably borrowing Tim Shadbolt's fucking wheelbarrow or concrete mixer. So, you know, and he's got a wife that does the psychological side of things that he refers through the court to that place. I mean, that to me is another conflict, isn't it? Have I got that right, or am I?
Yeah, that's right. Because that's what Darren was saying. She's a psychologist. Now, going by what I've looked up, she's based in it's either Sydney or Melbourne at the moment.
Right.
So, but the reality of it is, going by what I managed to find out, I'm still trying to find out if it is his wife, is she related to the lawyer for child because they have the same surname?
Yeah, and the lawyer for child was sitting there crying about the fact that you'd filed a tort of professional negligence against her at the last hearing for your kid or your grandkid, and I mean, you're there at the hearing. How did the lawyer put it? That's a you problem, not a us problem.
That's right.
You know,
so that's why I now turn around and say to them that if they turn around and say stuff you know, how I put it first of all, oh well, that's a you issue, not a me issue. Exactly. They don't like it coming back on them, you know, but at the end of the day, I mean, this is now the lawyer for child that's failed to turn up for two high court hearings.
Yeah, exactly. So she'll be getting a contempt of court very shortly if she doesn't do that, surely.
Well, I would hope so, considering the justices keep saying how are we supposed to proceed when we don't have the counsel to assist the child.
Exactly.
And I turned around and said, well, more to the point, Your Honour, why is the child being left in limbo when this could be decided now, and it's simply not just because the lawyer for child's not here. Now, that is not in the best interest of the child.
Yeah. If they don't show up, then that should be an extra bonus for the party that has shown up and continues.
Well, put it this way, if it was you or me and we didn't show up, it's going to go in favour of the other party.
Well, exactly. I mean, here's a good example. You know, Steve Evans, dare I say his name, when he got his securities license in the North Shore, I was there. I mean, there was a recording made. Let's just say that. And when I released a little bit of that recording, where the Judge Harrison was busy reaming the fact that the prosecution couldn't even show up for the hearing, so it was literally just Steve and his legal representative Ashley, and Ashley just got to tell the whole story from start to finish for about an hour and a half, and then he says, "Oh, reserved decision, you know, blah blah blah. I'm going to go away and think about it." If we hadn't released that bit of the audio showing that that he was in favour for Steve beforehand, I lay a bet, and if he didn't think someone else had a recording, he would have found in favour of the police anyway. But it's only because he knew what he had said in the hearing had been released to the public, because then he tried to hold Steve in contempt of court for supposedly recording the hearing when he had nothing to do with it. You know, and then the judge starts looking at me, and I just gave him 3 examples. I says, well, here's a minute from Judge Nicola Mathers saying that unfortunately the court audio recording system failed to record the hearing, so you guys lost a complete 5-hour hearing. So that shows the court's incompetence to keep an accurate record of the hearing, and that's the whole point of the court of record, is to keep a record, for fuck's sake. Then I said, I won that case. So you know, it's the same fucking thing. If one party shows up, it should naturally go to you, and they should. And a lot of the times, the judges will start being more in favour of the prosecution usually, and just play as advocate for the prosecution, and you're sitting there basically playing against one side with two players.
Yep, I know where you're coming from, because when I went up with the Communist Commission, it just made me laugh. As soon as I heard the lady say that it's been going since 2020, my first thought was, you haven't been in this long enough.
Yeah, well, what were you saying about all the registrars having to get trained by one person alone? I mean, Jesus. So if that one person's misinformed, she's then misinforming the entire judiciary, the entire registry system.
Yep. So what's happening now apparently is any applications that's made through New Zealand for the High Court
goes to Wellington. Yep.
They go to Wellington and then they get reassigned to go back out to. You might have done it in Auckland. It goes down to Wellington. It gets reassigned back to Auckland, and then
we did that, and there was another reason for doing that too. And that's to let them the end result. Say if we're sending it to Palmerston North or Rotorua, I think with Sabon's case. We sent it to the Wellington branch and they forwarded it through to the Rotorua, and then Rotorua knew that the Wellington branch was aware of the matter, and it's not and all of a sudden there's a third party that knows about it, that's in the registrar system, and they've got that extra little on the back step because they're worried now because they know that the main branch has got an eye on them, so to speak.
It's like with my one.
They can't keep it just incognito between Rotorua and, say, Sabon.
Yeah, it's like with my one. They what they were trying to say was, and this is what the Relevant Registry said because I actually got it in the email. Right? And this is what the lawyer said that the registry is only allowing the applications to go through for me because. Yes, they meet the standard, but they meet the standards and stuff like that. But from there onwards, they prefer if the court and council dealt with whether it was appropriate or not.
And sorry, we were talking about that Manukau one too. The Manukau branch had even heard about you.
When the guy came in,
sounded like an obnoxious prick at Manukau. I'll tell you, mate, I have nothing but problems with Manukau Registry. I asked them on the 18th of April for the transcript of the hearing. It would have ended up being probably 2 or 3 pages maximum for them to transcribe, because it was the shortest almost as short as the Hamilton one, which was 1 page. So, and they haven't supplied it. And I've told them that I need it for future legal proceedings. No, not supplied it. And Tony got supplied for the disclosure. Finally got the witness list and exhibit lists, now listing new exhibits of YouTube videos which they haven't supplied us in disclosure. And it's only 5 months late from the court section 30 court order stating that they had to supply full disclosure within 30 days. No, it's only 150 fucking days late. We won't worry about that. They're just, and Tony's just said that not only has he received that shit on the 17th of May, he's just got another envelope from them yesterday or today with more disclosure.
Okay.
Perhaps it's the YouTube video or something. Or we don't know, because he only just informed me today, and he's busy at a function. So, but yeah. So they just keep throwing this shit at him. It's just more fuel for my submissions in support of the application that these guys are now continuing to fail in the prerequisite requirements of disclosure. So they've already breached the court order.
I'm going on that. I would say that more than likely you'll be applying under the Evidence Act to strike it out, don't you?
Well, you can do under Section 130 of the Evidence Act. In fact, I think it is because I don't know if you remember, this is back in 2014 or 15, shit, almost 10 years ago now, when Constable Neil Winterbottom ran over my foot in his police car and then took off after giving me a speeding ticket. Let the record show that piece of shit there decided to stick that there, which he can have back. You're not walking away from me, buddy. You're not walking away from me. You're not walking away from me. Oi! What are you doing? Excuse me? Don't walk away from me. You can have this back. Don't you try and run me over, mate. Don't you dare. You're running over my foot right now. Back off. You're on my toe. Look at this, he's run. Get off my fucking toe! You're moving forward, back up! Get off my toe, you are! Get off of my toe! You evil man, you're being done for assault! Well, I took photos. This happened in November, so I didn't want to fucking upset the family routine through Christmas, so I just waited until after Christmas, and then I went through the footage, and I still shotted the car's tyre on my foot because I had it on footage. And because I'd taken, and this was only for reference, I supplied them the whole fucking raw video. It's not like it was edited in any way. And I supplied them snapshots of the foot, and they said that that was not admissible as evidence because it could have been altered in some way. All I did was take a still shot, and they refused to accept it. And lo and behold, on the day, their TV system wouldn't play a standard AVI file. So, you know, I got it. I got $100 off the fine. You know, but regardless of that, you know,
that's where we're at the moment. We're just waiting to go back on the 3rd of June. We're waiting on a court hearing for the two that he Black turned away. And then when I did the one that Justice Palmer said, you know, do it without notice, and then if it comes back, you know, even if it's a decision not to make a decision, well, I've now just received the minute to turn around and say that even if that appeal is not in the registry, it is to be brought up on the 3rd of June, so it can, so the appeal process can start alongside of the judicial review process, because this matter needs to be ended as soon as possible.
It shouldn't be what's the word? Left adrift. You're not prepared to have it left adrift endlessly.
Timothy Black, okay, the matter should not be left adrift for months, and I am not prepared to allow that.
Exactly. Remember, it's all these admiralty terms and shit you've got to throw in there sometimes.
I mean, my first question when he put that out was, okay, so any reason why you let the OT proceedings drift for 21 months instead of 60 days?
Oh, because they get paid more if they deal with the cases. I mean, they get to string out the legal aid, and they get to, you know, 470 million, I think it was, just a year or two ago for that was paid out to legal aid, not to mention.
Total salaries for District Court Judiciary $81,023,800. Totals for Supreme, High, Appellant and District Courts. Total salaries for Supreme Court Judiciary $3,187,100. Total salaries for Appellant Court Judiciary $4,669,900. Total salaries for High Court Judiciary $21,188,300. Total salaries for District Court Judiciary $81,023,800. Yearly total of salaries for combined judicial officers $110,069,100. Is your trust and confidence in the judiciary worth that?
111 million that was paid for the judges. So I mean, there's over $500 million there. Is everybody happy with the justice system?
The criminal side of it is interesting. Well, I found it to be interesting because it's the first time I've had to deal with the criminal side of it.
Sure.
And when I went up to the Commerce Commission one, the one thing that I did find very, very interesting, listening to them in the morning, but when they were setting up how the afternoon was going to go, if you've been up before the court 3 times to try and go to hearing, you are able to be, basically, it's, what do you call it? It's a guarantee of a 147 discharge.
Yeah.
If they can't hear you the first 3 times, the 4th time they must discharge the.
Does that mean the person actually attending, or just a date being set? Because, you know, like in Tony's case, we were in court on the 9th of November. It got set for a call-over date to the 25th of May. Then we filed an application for dismissal 3rd of February. Then that May call-over date got changed to the 18th of April. Then on the 17th of April, we were notified that they didn't have enough judges to actually hold the trial. So it got put back to the 25th of May. Then it got changed from the 25th of May now to the 29th of June, which is where we're at. So there's 4 dates.
Yeah, going by what Judge Harrop said that day,
Yep.
The lawyer was inquiring about being able to do the 147 discharge.
Yep.
He said he's been up 3 times before. I can see that. I can see that the last 2 it has been listed as high priority. I will again list it as high priority. If it doesn't go ahead next time, on the next date, it will be dismissed.
Yeah.
So it goes to show you that if you can get it pushed out enough to the point where the hearings don't occur, the justice system has to give up on it. Because as he put it, we have to deal with them in a timely manner. And if we don't have the ability to, we can't string the defendant along on the basis that the prosecution is mucking around.
I believe it's somewhere actually in the Criminal Procedure Act 2011 about the timing and the timeline. Like, for instance, a Category 1, they must have the first hearing within 6 months of the offence, and the matter must be dealt with within 12 months of the offence, unless a judge extends the timeline. And
but if they start extending it, then once they start extending it, that's how it becomes high priority according to Judge Harrop.
Yeah.
Right? And on each of those extensions, if you get past 3 extensions, and the 4th time doesn't go ahead, it must be dismissed. Now, in a way, how silly is that? Because if you've got a very serious crime that's happened, okay, and the person really shouldn't be on the streets, then as long as they've managed to pass 3 times and they've reached high priority, you've got to dismiss the charge against them.
Yeah, and that happens so many times. I mean, I was in with another gentleman at Waitakere Court probably a month or 2 ago now, and the person, because we were just sitting there waiting for the name to get called, and the person before us popped up, didn't appear, and the lawyer piped up and says, "No, I'm sorry, this person's still got COVID," and he goes, "He must have long COVID because he's had that for the last 4 times. It's going to be adjourned for a 5th and final time." And I'm sitting there thinking, this guy's keep putting it off. Surely it could just be cancelled now because of the length of time it's taken for the trial to occur. Because I mean, that's one of your rights in Bora, to have a speedy trial.
That's right, and it's also the fact that it's in the Bora for a speedy trial, but it's also the fact that if you go by the family court proceedings where I sat in as a Mackenzie friend for someone else, if it's been over 6 months, then it's now prejudicing the defendant.
That's right.
Because they had the right to that speedy trial, they didn't get it, so now you must drop the charges.
Yes.
So it's been an interesting last few months, but I mean, still learning different other things bit by bit, day by day. I mean, I did, when I went to that meeting the other night, there was an old fellow there that's 85 was telling me his thing through the family court system, and that he had dealt with that at one stage. And he said the only words he said to Judge Beck was, "Corpus juris secundum, bye bye."
Oh no, nothing's worse than Timmy with authority.
Bye-bye now.